Hello viewers of Kritika's Vision, welcome to yet another episode of my lecture series. Now we will be doing again the functions of Supreme Court, and we'll today deal with the appellate jurisdiction. So yesterday we did that how jurisdiction is the power that a court or a law exercises to carry on judgment, and we even discussed the original cases to which the Supreme Court has exclusive right to deal with. Now today we'll do about appellate jurisdiction, that is a court of appeal is any court which may change the decision or reduce the sentence passed by the lower court. So the Supreme Court in India is a final court of appeal. Yes, beyond Supreme Court, we cannot apply to any other court to change the decision or to reduce the decisions of the court. Now, an appeal lies to the Supreme Court from any judgment or final order of a high court in India. The appellate jurisdiction extend to following cases. So number one is the constitutional cases. Now, every high court has a power to interpret the constitution and to issue writs, as I have told earlier in the previous lecture, for the enforcement of fundamental right. However, on matters involving interpretation of the constitution, though the high court can deal with it, still Supreme Court has a last word to say. So appeal lies to the Supreme Court from any judgment of a high court if the high court certifies that the case involves interpretation of the constitution, and if the high court refuses to give such a certificate, the Supreme Court may grant a special leave to appeal for those cases. Next is civil cases. Yes, appeals in civil matters lie to the Supreme Court. Now, if the High Court certifies that the case involves a substantial question of law of general importance, then the appeal will go to them. And next is when the question needs to be decided by the Supreme Court, there is no bar on Supreme Court howsoever to grant special leave to appeal. That is, without a recommendation made by a High Court, still Supreme Court can go to any case that it wants to. So, and the third one is appeal in criminal matters. So, there are two types of ways in which an appeal in criminal matters can be brought to Supreme Court. Number one, with a certificate of High Court, and number two, without a certificate of High Court. So, with a certificate of High Court means an appeal lies to Supreme Court if the High Court certifies that the case is fit to be held and to be dealt in Supreme Court. And without a certificate, when the appeal lies to the Supreme Court, if the session judge has acquitted the accused, but the High Court on an appeal from the government reverses the judgment, and if the High Court has withdrawn any case from a subordinate case court and has convicted the accused and sentenced him to death. So in both these cases, without the certificate of High Court also, the Supreme Court can deal with those criminal matters. Okay, so in today's episode, we have dealt with the appellate jurisdiction, that is the appeal, the power of appeal of Supreme Court in India.